And thank you! What happens when you cross a chicken with a duck? You get a hen that lays down! Ah!
Hey everybody, welcome to American Courts. I see Jolie said the volume was down. I did have the volume down for the music. That's more my style of music. I don't want to bother other people that don't like that kind of music, so I try to lower the volume down on it. It was meant to be down to the point. I was trying to take the audio or the lyrics out of it, but I forgot to do that. So it gets hectic in that last hour, and I messed it up a little bit. But it was fun to see Fozzie wreck a drone. It's great to play around with those toys, but you will definitely wreck them. You'll wreck them. You'll lose them. You'll at any point everything that can go sad will go sad with it. But thank you, Fozzie, for sending me that. Thank you everybody for jumping in. We got Linus, Fozzie, Emily, Nancy, Victoria Bernal, who was so nice to me today in the courts chat room. Thank you, Victoria. Julie, hey, always good to see you here. Maiko's here. Vicky Johnson, hey, how are you doing? So today in the courts chat, there was a lot of discussion about medicine and drugs. And just a word of advice to the small group here, it's just not worth it. It's not worth it to talk about. It's not worth it to mention it because the rules are so vague about it, and what the rules are not vague about it, we just don't know. And I don't know. I at my point, at my level, I'm just going to go ahead and get rid of it because you just don't know what it is. So if anybody got offended or anybody got their feelings hurt on it, uh, I apologize if I deleted anything out of there. Julie's volume's still down real low. Let's see. Everybody give a volume check if they can hear it. I'm trying to look for other volume controls. Okay, it shows I'm at 100% of the volume that this thing is willing to give me. So let's see what I can boost up. Julie, you're always great. You're always great, whether it's in the courts chat or here. So look, I got these big headphones on my ears, so I can hear everything. So just sounds good to me. Emily's got headphones on. Julie's saying low. Metal Rolls is low. LD is fine. How about this? I'm going to jump into court. Ouch. Ouch. Mike is AC talking? No, I am definitely not. So I'm going to go ahead and jump into court because that's more fun than hearing me talk anyways. So let's jump into Judge Boyd.
Court is calling 2024 CR 1943, State of Texas versus Isaac Chavez. Can I have parties announced for the record for the state? Defense?
Doug Campbell for the defense, ready.
And are you Isaac Chavez?
Yes, ma'am.
Are you the same Isaac Chavez who was placed on deferred adjudication in 2024 CR 1943 for the offense of possession of a controlled substance, penalty group 2, 4 to 200 grams on April 15, 2024 for a period of 4 years? Is that you?
Yes, ma'am.
State?
On or about the 22nd day of June 2024 in Bear County, Texas, the defendant Isaac Chavez committed the offense of evading arrest or detention of the vehicle in violation of condition number 1. Your Honor, do you want me to read all of these and then allow Mr. Chavez to give his plea
All right.
total or each one individually?
All right. Let me ask Mr. Chavez, with regards to the alleged violations of conditions, there's a violation of condition number 1, 2, 8A, 14C, 14Z, and number 34. Are you pleading true or not true to those allegations?
Not true.
To all of the allegations within the motion?
Yes, Your Honor.
All right. Then the defendant is pleading true to violations 1, 2, 8A, 14C, 14Z, and 34. All right, State, do you have witnesses?
Yes, Your
All right, State, you can call your first witness.
Honor. State calls Angeline Nicholas.
All right, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand, state your name for the record.
Angeline Nicholas,
All right, State.
Ms. Nicholas, how are you currently employed?
with Bear County Adult Probation.
And what do you do with Bear County Adult Probation?
Supervise cases and,
I'm sorry, you're gonna have to keep your voice up so the court reporter can hear.
sorry. I supervise cases, make sure that they're following the conditions and
There is a microphone in front of you. If you would put it up using the microphone so the reporter can hear you.
sorry.
Do you supervise a person named Isaac Chavez?
I do.
Is that Isaac Chavez with Bear SID 1158-016?
What was the, so?
1158-016?
Yes,
And do you see that Isaac Chavez in the court today?
I do. Yes, right, yes.
Could you point him out so the court by an article of clothing?
Gray dress shirt,
Thank you. When did Mr. Chavez begin his supervision?
April 15th, 2024.
Now, on June 22nd of 2024, did Mr. Chavez make an admission to you regarding his use of alcohol?
On June 24th of 2024, that's when I met with him, but he did admit that it happened on June 22nd, yes.
And when you say it happened, you mean that he consumed alcohol?
Yes.
Now, Mr. Chavez had a number of conditions of his supervision. Among them was to complete one AA meeting per day for 60 days.
Yes.
According to your supervision of Mr. Chavez, how many AA meetings per day did he complete?
It was more so one per week.
And how many in total?
8.
Did Mr. Chavez provide proof of employment or SSI within 30 days of his release?
No,
Has he provided any proof of employment?
no,
Did he register for or attend a drug offender education program?
no verification has been provided.
Now, did you give him a referral for a drug offender education program?
Yes,
Did he provide any documentation that he registered for it or attended?
no,
Did Mr. Chavez at any point provide proof of residence?
no,
Passage, Your Honor.
Defense?
Ms. Nicholas, were you aware that Chavez was living at 8603 Cape Valley?
yes, he let me know that he was living there.
What more proof would you need than his word if he was living with a parent or somebody else?
You said what more than his word?
Mhm.
Usually, if they're living with parents, the parents need to write a letter stating that he's living there with a proof of one of their bills.
Did you tell him that?
I don't recall.
Did you ever go out there to see if there was any proof that he was living there?
No.
With respect to the once per day for 60-day Alcoholics Anonymous classes, are you sure he was aware of that?
Yes,
How are you sure he's aware of that?
his conditions were read to him in court, actually, by the CLO.
And at the time he went on probation, he was 19 years old.
I believe so.
Have you ever, in your dealings with Mr. Chavez, had the thought that perhaps he might be a little bit immature?
I mean, yes.
And as a result, do you think that maybe he didn't fully comprehend what was being told to him?
I wouldn't say didn't fully comprehend what was being told. It's just maybe more so of kind of just taking his time with it. I mean, I'm sure he fully comprehended what was needing to be done.
As a now 20-year-old, he probably has a little bit more sense of urgency on needing to get these done, especially since we're here in court, right?
Yes.
Were you aware that he was working at Willie's?
Yes.
And you say he never gave you proof. What steps did you take to try to verify that he's working at Willie's?
We normally ask for proof of employment.
Did you discuss that with him?
Discussed it, yes. I didn't document it though, if I'm being honest.
Did you tell him, hey, when you really need proof?
I didn't make it an urgency thing. to be
Okay.
honest with you.
And then with respect to his drug offender class, having dealt with 20-year-olds before, and certainly somebody who lives with a parent at 20, do you think maybe he was waiting for you to do something? No, you think he was fully aware that he needed to
Yeah.
take that extra step and set up the class himself?
Yes, because we provide the verification, let them know like, hey, go through the list, figure out where you're gonna go and register. That responsibility is totally on him.
Okay. And you say that Isaac had admitted to using alcohol as a 20-year-old to you.
Mhm.
Do you think he benefits from perhaps some additional classes on the dangers of alcohol and drugs?
Yes,
Do you think, now there was a report written for the court, right?
yes,
Did you write that report?
most of it.
Most of it? Do you agree with the recommendation for this particular person?
No, not necessarily. For the younger probationers, I tend to be a little bit more compassionate, give chances, hope that they'll learn better. So I wouldn't say no.
Do you think Isaac should have another chance at trying to be successful on his community supervision?
Yes.
Why do you believe that?
Like I said, I just try to give a little bit more compassion to the younger ones because they're a little more respectfully hard-headed, and it takes them a little more tries to get it right.
That's especially true with male defendants or
I would say
clients, I
all of
guess.
the younger ones.
Yeah.
I wouldn't specifically say no, all of the younger ones.
Okay. Do you think he can be successful now that he knows how serious this is?
Yes,
Why do you believe that?
because this is his second MTR, I believe. I think at this point, we know to be serious.
All right, it's his first MTR.
First, in this case.
In this case, yes, sorry.
Yes.
Thank you. I'll pass the witness.
Any other questions?
Yes, officer, do you have a copy of the court summary in your hand?
Yes.
Can you please turn to page 3?
Yes.
Underneath the field marked justification, there is a signature line that says community supervision officer. Is your signature above that line?
Yes.
Would you please read the recommendation that is above that signature line?
It says revoke no offenses and non-compliance.
And below that is justification. Would you please read the justification?
The probationer bonded out on new offenses, and he has not reported to probation since bonding out. The probationer has not shown a valid effort to comply.
Now, as part of your duties, is it your responsibility to proactively investigate the information that a probationer is required to produce to you?
Yes.
Yes. So, for instance, if a probationer is required to produce proof of employment, are you obligated to go out to his potential employer and get proof yourself, or is he responsible for providing it to you?
Oh, he's responsible for providing it. We don't go out to the employers. I could always ask the field team to do that. But they're responsible for providing verification. adjudication.
And for proof of residence, it's the probationer's responsibility to provide that proof to you, correct?
Yes,
And for proof of attendance at Alcoholics Anonymous meetings, it's the probationer's responsibility to provide that proof to you, right?
correct.
Same for registration and attendance at a drug offender education program. It's their responsibility to provide proof, not yours, right?
Correct.
So, on or about the 24th day of June 2024, did Isaac Chavez provide proof of residence as required under condition 8A?
No,
On or about the 24th day of June 2024, did Isaac Chavez provide verification of Alcoholics Anonymous meetings as directed by the court, as required by condition number 14C?
no, those are, no,
On or about the 24th day of June 2024, did Isaac Chavez provide proof of registration for or attendance of a drug offender education program as required by condition number 14Z?
no,
On or about the 24th day of June 2024, did Isaac Chavez show proof of employment or SSI within 30 days of release as required by condition number 34?
no,
Is Mr. Chavez prohibited from consuming alcohol under the terms of his supervision?
yes,
Is that under condition number 2?
yes,
Did Isaac Chavez admit to consuming alcoholic beverages to you?
yes,
Did he admit that he consumed alcohol on or about the 22nd day of June 2024?
yes.
Thank you.
Any further questions?
Oh, Your Honor.
All right, thank you. State, call your next witness.
Calls Officer Ramos.
Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
I recently got married, so technically my name is Brianna Gonzalez.
I object.
All
Yeah, so
right,
I know my name still says I just got married on the 9th, so
all right, congratulations.
thank you.
All right, state.
How are you currently employed?
I'm employed as a police officer with the Leon Valley Police Department
And how long have you been employed with the Leon Valley Police Department?
since March of this year.
And what is your current assignment?
I'm a patrol officer for the city of Leon Valley.
On June 22nd, 2024, what was your assignment?
Just regular patrol duties as a patrol officer.
And are you assigned to night or day?
At that time, I was assigned to days.
On June 22nd, 2024, at approximately 7 a.m., were you dispatched to a particular incident?
I was dispatched to what I believe was a welfare check, what it came up as on the CAD system, to go check on, or I'm sorry, that was your question, yes.
Yes. And the location to which you were dispatched, that was in Bear County?
Yes,
And when you arrived at the dispatch location, what's your
I observed a car on Huebner Road, just on the street. The light was green, but the car was parked, or it seemed to be parked. I don't know if the driver's foot was on the brake or if it was in park, but they were stalled in the middle of the road as if they were parked.
And can you briefly describe this vehicle?
The vehicle was a Lexus, 4-door vehicle.
Do you remember what color it was?
I don't, I know it's on my report. I put it down. Was I supposed to have that with me? Sorry.
That's okay. So, upon seeing this vehicle, what did you do?
Well, because of the notes in the system, I activated my red and blue lights and I got behind the vehicle to initiate a traffic stop.
Did you get out of the vehicle, out of your vehicle?
I did not get out of my vehicle at that time, no.
And what reaction, if any, did the operator of that Lexus have to you activating your patrol vehicle's emergency overhead lights?
Initially, the operator of that vehicle did nothing. When my partner got out of the car, along with another officer that also pulled up to that traffic stop. They both got out of the car. I was about to get out of the car, but then the vehicle suddenly drove forward and it stopped in the middle of the intersection of Huebner and Bandera Road.
What happened next?
What happened after that is we all got back in our vehicles. We both got closer to the vehicle. Then we tried to get out again. I stayed in my car at that point. I didn't get out. And again, the two officers, the one in my vehicle and the other officer, got out to try to make contact with that person again, and that vehicle fled and evaded. So at that point, I told dispatch that I had a vehicle evading arrest.
And at that point, what did you do?
At that point, dispatch asked if I was in pursuit. I said no. So I was still behind the stopping point for that road. So I abided traffic laws and I waited for that light to turn green. That way I could turn.
Now, a short while later, did another officer communicate to you that they had detained the vehicle?
It wasn't communicated, it was observed. Because I could see it. It wasn't very far at all.
Okay. Was this vehicle the same vehicle that you earlier observed and that sped away from you?
Yes.
What did you do upon relocating?
Upon relocating to that vehicle?
Yes.
Oh, well, again, my lights were already off. So all I did was, as soon as the light turned green, I turned left onto Bandera Road and I got next to because my other officer, he had initiated a second traffic stop. He initiated his red and blue lights again on the same vehicle, and I stopped with that officer to try to initiate contact again.
And did you initiate contact with the operator of the vehicle?
Yes, eventually, because again, the other officer made that second traffic stop technically, and then we took him into custody at that point.
Did you identify the operator of that vehicle?
Yes,
How did you identify?
we asked him for his name eventually.
And what did he say?
He said his name was Isaac Chavez.
Did he provide a state issued ID of any kind?
I don't recall.
Did he give you a date of birth?
He had to have, yes.
Let's not operate on your assumptions.
Yes, he did.
Okay. Do you see the operator of that vehicle in court today?
Yes, I do.
Would you please point him out to the court by an article of clothing?
He's in black pants and a gray dress shirt.
Now, after you detained him and began to interact with him, what observations, if any, did you make?
He appeared to be intoxicated.
Did you observe the odor of alcohol emitting from his breath?
Yes,
Did he admit to consuming alcohol?
yes.
How much alcohol did he claim that he had consumed?
Initially, he claimed that he only had one drink, but upon further questioning, I asked him, okay, what did you drink? And he said he drank Modelo and Smirnoff, so it didn't make any sense.
Did you make any other observations about his physical appearance?
Yes, he
What observations were those?
he appeared to have urinated on himself.
Is that the only other observation that you made about his physical appearance?
Other than his glossy red eyes, he appeared to have soiled himself and the odor of alcohol on his breath. No, that was about it.
Did you ask Mr. Chavez to submit to standard group sobriety tests?
Yes.
And what was his response?
His response was he wanted to speak to a supervisor first.
Did you call the supervisor?
I did.
And did that supervisor appear?
Yes.
Did that supervisor speak with Mr. Chavez?
Yes.
And after speaking with that supervisor, did Mr. Chavez submit to standard group sobriety tests?
No, he refused.
At that point, what did you do?
We formally told him he was under arrest for evading and DWI, and we read him his rights, and from there we transported him back to our police department.
Okay, thank you. Pass the witness.
Officer, would you agree with me that all things in life are a matter of perspective?
Not all things.
How can you be sure that Mr. Chavez saw the lights when you were behind him?
How can I be sure?
Mhm.
I mean, he's not legally blind as far as I know, so they're really hard to miss, so I can't be sure, but any reasonable person, even intoxicated, could have seen those lights.
And he pulled over immediately when the other car stopped him, right?
Well, he was actually already stopped at the red light, so he didn't technically pull over, but he didn't make any further attempts to flee at that point.
Right, and I guess that's my point. If he was just, based on what you're saying, he was asleep in the intersection, right? If he's just waking up, we're not sure he even knew you were there, right?
His eyes were open when I saw him.
Did he recognize you? Can you say that he recognized you?
I could say that he could have recognized a police officer in a police car with their lights on, yes.
Should have, but there's a chance that he didn't, right?
I'm sure, yes, there's a chance.
And during your interactions with Isaac, was he cooperative for the most part?
For the most part, yes.
And he courteous
For the most part, yes.
and compliant? Once he was stopped, right?
Completely compliant, but the other questions.
And you don't know what his blood alcohol level was because you don't have the labs back yet, do you?
Well, he didn't consent to blood, actually. He initially did and then didn't. But he had a blood draw, so no, I don't know what those results are.
So you can't say with certainty that he was intoxicated.
No, I can't.
Thank you, I'll pass.
When you spoke with Mr. Chavez, did he slur his words?
Yes.
Did he stutter?
Stuttering, I don't recall, but slurring, yes.
Nothing further, Your Honor.
No further questions.
Thank you.
Thank you.
State, any other witnesses?
That's all, Your Honor.
I'll call Isaac Chavez.
All right, Isaac Chavez. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Isaac Chavez.
All right, defense.
Thank you. Isaac, we've already identified you as the same guy who's on deferred adjudication for possession case, right?
Yes, sir.
Can you tell the court what was going on June 22nd of this year?
The day I was
Yeah.
yes, I was at a friend's house. It was just supposed to be a normal hangout, but he ended up inviting other friends. I do admit that I did have alcohol, but I was peer pressured. I was trying not to at first, but just to fit in, I fed in.
Now, just to be clear, you're 20 years old, right?
19 at the time.
19, okay. And despite all of that, you understand that it's illegal for you to drink alcohol when you're under 21 in the state of Texas, right?
Yes, sir.
And despite all of that, you told your probation officer that you were drinking, right?
Yes, sir.
And did you see the police officer who was behind you in the intersection over in Leon Valley?
Not the person.
If you did, what would have happened?
I would have put over immediately.
And that you didn't try to run off when the second officer stopped you, right?
No.
I'm gonna ask you a question. I told you I needed you to think about this. Why do you think the court should continue you on deferred adjudication?
Truthfully, it's just I do acknowledge that I made a mistake. I acknowledge that I was irresponsible. But truthfully, for the past 3 years, I've been completely sober. I've been working honest jobs, helping with my family, my grandfather. Honestly, I was on the straight road. I was doing everything right. I don't believe.
Let's focus on some of the other violations that they've alleged. You've already told the judge that you admitted to drinking, that you did drink. Why didn't you ever provide any proof of where you were living to your probation officer?
I didn't necessarily know how. I told her where I lived and I had my ID. I didn't really know what more proof was needed.
And the 8603 Cape Valley address is on your ID?
Yes.
And they looked at that every time you went in, right?
Yes.
So you felt like you complied there.
Yes.
There's another allegation that you failed to go to Alcoholics Anonymous every day for 60 days. Did you understand that that was one of the requirements of your community supervision?
I did.
Why didn't you go every day?
I did actually go every day. I have the proof in my cell phone. I have the email sent to my probation officer. I have about 56 of them of every day that I went.
So do you take issue with the fact that she only testified that you went once a week?
I do, yes.
What did you learn, if anything, at the Alcoholics Anonymous meetings?
So let me just stop you. Where is the proof of this?
Judge, I don't have it. It's in his cell phone. I can't. I'm
Oh,
not
where's the
gonna-
cell phone? Did anybody look through his cell phone?
I did not, because I asked him to print them.
All right, you all want to step back and state, you can look through his cell phone and see if there's actually documentation that he did it, and I'm sure if he did it and it's proof there, maybe the state will waive the,
Well, it's just one, Judge. I got other ones I still got to address.
I know, but step back, let's see if he actually did that. All right. Johnny Tejeda? All right, Doug Campbell, you ready on your client?
Again, yes. Yeah. Judge, we've had an opportunity to talk.
Mhm.
We've got an opportunity to talk about your two options.
Mhm.
And I think my client would like to take the local ISF,
Okay.
if that's an option.
All right, we're back on the record and cause number 2024 CR 1943, state waive 14C without objection. Court is finding violations of condition number 2, the consumption of alcohol true. 14C, state waived it. 34, the court will find true. 14Z, the court will find true. 8A, the court will find true. Number 1, evading arrest or detention, the court will find true. Number 1, driving while intoxicated, the court will find not true. All right, probation, my understanding in this case, you're not recommending revocation? Oh, I'm sorry, they are recommending revocation. All right. All right, this is what the court is going to do. Court is going to deny the motion. Alter and amend conditions. To include probation. Since I'm denying the motion, do you recommend local ISF or state ISF? Because it appears we have alcohol issues as well.
Judge, so I did speak to defense counsel and I talked about ISF that is just going to address cognitive. However, if you do send him to state ISF, that you could order him to be substance abuse cognitive track.
Mhm.
Obviously, there's differences in the wait time in custody for both facilities. So that is something I think defense was going to address.
Well,
Somehow,
sometimes that's punishment.
fair enough.
All right. So it's going to be state ISF. And there's to be partial GPS for employment only upon release. And I'll ask that GPS fees be waived. Probation, is there anything else?
Judge, is that going to be through the jail?
Yes.
Thank you. I think that'll be it.
All right, all other conditions will remain.
Oh, Judge, I'm sorry. Is that substance abuse cognitive track?
Yes. All right, anything else?
No, Judge.
All right, we can go off the record. You had better start doing better. Otherwise, you're going to prison. And let me just tell you what's going to happen in prison. It would be nice if you go to prison, everybody leaves you alone. You're just doing your time, but people are not going to be leaving you alone. You're young, you know? And I'm telling you truth. you're going to be sold for a pack of cigarettes or some extra dessert. That's what happens at the prison sometime. And this persona that you're giving me now, that's not going to help you at the prison. And maybe people will start fighting with you. Maybe sometimes somebody at the prison be like, I don't feel like fighting with him today. They may say, yeah, I feel like fighting with him today. And that's what you're going to be doing. And the fact that you're young and you're doing dumb stuff is not going to help you at the prison. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge.
So Judge Boyd there gave him an ISF, which is intermittent sanctioned facility, it looks like more like a treatment center around kind of a jail attitude with it. Someone can correct me if I'm wrong on it. I had to look it up there. But she definitely, let him know that he was pretty enough to be traded for dessert. And so Miko's saying I'm not buying, love my desserts too much. Absolutely. I don't feel anything about going to jail would make me change my opinions of people. So I think if I went to jail, I'd still have the same interests. But we got one from Gulf County. The sound is a little bit choppy at the beginning because it's Gulf County, but Nancy, don't they rap men in there? I'm sure there's rappers. There's probably country singers and rock singers and all that, but they definitely rap in jail. So, but we'll go to Gulf County and see where that goes.
Mr. Williams?
Yes, good afternoon, Your Honor. How are you today?
I'm well, sir. How are you doing?
Doing very well. Judge, I have one client there, Henry Lee Davis. He's in your jury box over there. He should be.
Okay, Mr. Davis.
So, State of Florida versus Henry Lee Davis, Your Honor, I have two case numbers, 24 CF 42 and 24 CF 59. Your Honor, we're presently on a trial track for that October 28th date. Mr. Davis has rejected the state's offer at this point, which was the lowest permissible sentence offer. So I just request that we stay on track and maybe come back on that 10/25 for another trial management in case we have a resolution.
Okay, so we'll see for
Yeah.
trial. Yes,
May I
sir.
speak to the open court? Okay, he's not representing me properly. I don't feel like I'm being represented properly by him. That man is the man that said, "Oh, just take the charges, just take it, you did it, whatever, just be done with it, just be okay. Just this is low permissible." I've read up on it and it says not exceeding within 5 years on the charge of third-degree felony. This man saying, "Oh, they can give you 10 years. The charge holds 10 years. Just take 5 and you'll be okay." I don't feel like he's want to represent me. I don't feel like he's willing to represent me. I don't feel like he's capable of representing me.
Okay, you'll raise your right hand.
Yep.
And everything you told me, Mr. Davis, is true and accurate to the best of your knowledge. You're asking that I discharge Mr. Williams?
Yes.
But if you want me to discharge Mr. Williams, what I'm going to do, I'll ask Mr. Williams a few questions. And if I don't find that he is rendering ineffective assistance to counsel, you can still discharge him if you want, but the state will not be required to give you or provide you any other counsel. You will simply have to represent yourself.
All right.
So you're telling me that the state's offer is 5 years DOC?
68.4 months.
68.4 months. And you're saying because the charge is a third-degree felony, it says it cannot exceed 5 years?
That's what it said.
And Mr. Williams is telling you that, in his opinion, you should accept the 68.5 months.
Yeah, he said I should accept the 68.4 months. I got to know where I'm at and realize what's going on. And I'm Pacific. I'm gonna say Pacific like he said it. She's white, you're black. Understand where you're at. It's not gonna go the way you're thinking. You really think they're going to listen to you? You think they're going to listen to anything you have to say with your record and all that? Like, there's no way you should be my lawyer saying nothing like that at all. to your client.
All right, Mr. Williams, anything in response?
Yes, Your Honor. I guess I'll start with that most recent statement made. Of course, I categorically deny that. I've never said anything like that. The only time the whole subject of racism, if you will, came up was when he brought it up, that he felt like he was a very racist town and that he wouldn't get a fair shake. And my only response to him was, I have not had that experience in Gulf County, that it was racist. With regard to the maximum punishment, the reason first of all, that we have two cases. They're both third-degree felonies. So I'm not sure Mr. Davis understands, although I tried to get him to understand, that each one of those cases as a third-degree felony carries a 5-year maximum. So when you total them up, which is what his total exposure would be, it's 10 years. The reason that the state's offer is so high, what initially you might think is so high is because of his prior record. The score sheet, he scores out to 68 point something months. But I never told him nobody would ever believe him, that sort of thing. I said, we basically discussed what his side of the story was, so to speak. And I just said, well, what about this with regard to the evidence? And then I said, well, what about this piece of evidence? How do you think the jury is going to react to this? How do you think the jury will react to that? I was basically just trying to get him to see what happens when you get into a courtroom with a jury present and the presentation of the evidence. It's just the kind of conversation that I and other defense counsel have with practically every client.
Okay. Yes, sir. Mr. Davis.
Okay. So, the conversation where he said, the other case that you have that you caught here in the jail, he said, that's going to hang over your head. We're going to deal with this charge first. This is the charge that we're at right now. The other charge is going to hang over your head. And sooner or later, once you get over trial, whether you more likely lose, they're going to throw that charge out. The charge is going to be throughout. They just want you to accept this charge. That's what he said to me. This man is continuously on the screen lying to y'all. This man is like very incompetent. The man came in there being rude off bat. He came in there being rude. It took me a minute, but I was calm. I was very calm with the man. The man told me, he come out and he tell the officer, we're having communication issues. No, there are no communication issues. You're sitting here trying to tell me to take something, and then you're trying to lie and fabricate it and make it seem good in your little way. But that's not the case. Everything I told him, I say, hey, listen, half of these charges that are on my score sheet are not me. It did not happen. I received 2 different sets of charges of priors that was not my priors. He said, we'll deal with that when you get in the courtroom. Haven't yet to say anything about it. Then you tell me, what he said. He said, I told him I said, I have a felony battery. I should not have a felony battery on this charge. It's caused of the mess. We'll get to that later. We'll get to all of that later. We'll deal with all that when it comes. We're not going to deal with that right now. We're talking. No, this is the charge that I'm on. Every time I tell him about something, that doesn't matter. That doesn't matter. That doesn't matter. How you going to tell me something don't matter? If it matters to me, it matters. You can't tell me something don't matter. You're supposed to be my lawyer. You ain't even representing me right. They just sit up there on the screen and try to lie, to try to make it seem good in your eyes. Come on, man.
What specifically about the felony battery? You said it should not be a felony battery.
Okay, I have a felony battery. And I've talked to my people. My people have been in contact with lawyers. They've been in contact with the state attorney down there in West Palm, where I'm from. And they have said, you have a felony battery, which you should not have a felony battery if y'all was living under the same roof. And both, if you claim she hit you, she claim you hit her, both of y'all should be arrested. Neither one, Drew is arrested, not her. And you have a felony battery, which should not be. It should be a domestic violence charge. I don't have no prior domestic violences. I have none of that on my record.
Are you talking about a pending charge right now?
I'm talking about the felony battery I have right now pending.
Okay, I have the battery in detention facility. What's the felony battery charge number?
2442, Your Honor.
And what does West Palm Beach have to do with this?
That's where my mom's at right now, and that's where she's talking to lawyers and getting in contact with people down there. I'm trying to figure out what's going on up here. because she's been trying to contact people up here and it's not working. Nobody's hitting, nobody's calling her back, nobody's emailing back. When I had Mr. Hill, my family was trying to get in contact with him. They never could get in contact with him. My family, I've tried to get his information. He told me he didn't have any cards to give me.
If I could, Your
Mr.
Honor.
Hill, I've talked to Mr. Hill priorly. When I talked to Mr. Hill said you don't have, I checked that you don't have any prior batteries. But then next thing you know, I get a prior sheet with prior batteries on it. Like,
The state's not charging you with felony battery based on priors. They're charging you with felony battery saying that you caused
I
great
understand
bodily
that.
harm.
That's what we're talking. That's what we talked about the first time. But I'm saying my score sheet, as he just said, my score sheet, I should not score out to that much because I don't even have none of them priors. I have about 4 or 5 or 6 priors that are me on them. They don't even have the priors that I went to prison for on them. That's how I know you're just trying to stack charges and trying to make it look like something that it's not.
Well, when you're telling me that Mr. Williams is not rendering competent and constitutionally effective counsel, I need to go issue by issue. That's why I'm at. You raised something about a felony battery.
Uh-huh.
What about your charge of felony battery? That you're saying your mom or someone from Fort Lauderdale disagrees that you should be charged with that? West Palm Beach.
She don't disagree. She's saying it's wrong. It is wrong. If we're staying under the same household and we had sexual relations, it should not be a felony battery. And especially if I said that she hit me and she say I hit her, they don't take her to jail, but then they take me.
That's a question. That's a question for the jury.
That's not. But it's not a question if it's a wrongful charge. You have me with the wrong charge.
Mr. Davis,
I'm sitting here, all you have to do is look at the paperwork.
Mr. Davis, whether you're living in the same house with someone or not, you can be charged with felony battery.
Are you sure?
Listen to me, Mr. Davis.
I mean, I have the evidence. I have the proof. I mean, if I'm looking it up and I'm finding this, my people are looking up and they're finding it. And they're asking other lawyers and other state attorneys, and they're saying the same thing. Y'all are going to say something different from what everybody else is saying. This is for the whole state of Florida. I've been on the phone constantly.
I agree with you.
I've been talking to people constantly. You cannot charge me with a felony battery. Felony battery is like if I go off out there and go to hit somebody. That's a felony battery. If it's somebody that I'm living under the same roof with, and we're having sexual relations, because it's what it said. I mean, I've read up on it. I had my people look up on it. They've read it to me. I've written it down. I've talked to my people. It's a DMD. So I don't get why y'all having with felony battery when it's not supposed to be a felony battery.
So you're under some lawyers telling you that regardless. Listen to me. I'm trying to understand. Your family or a lawyer or whoever they're talking to is telling you, regardless of the amount of damage that you allegedly cause, that you can cause permanent disfigurement, great bodily harm.
No
I'm not saying you did. Listen to me.
I walk in this courtroom 10 times.
Mr. Davis.
Come on, man.
Do you want to have this conversation to get through this, or you want to tell me what you want to tell me?
The conversation don't seem like it's being understood by nobody. Because you tell me, oh, it don't matter this. I'm telling you, if I'm giving you this and you're trying to give me something else, but I'm giving you what the law says. I've read in the law books and all. I've been in the law books. My people are looking it up and getting the same thing. You're trying to tell me something different to make me think that, oh, no, what you're saying is not right. When I know it is. If everybody's looking it up, I have different people looking it up out there. Everybody's telling me the same thing. I have people in here look it up. I've looked it up. I've even talked to Mr. Hill about it. I should not have a felony battery. There's no way I should have a felony battery on this charge. No way. And then they talking about my priors. That's not even me. Then you said, you should just take the charge. There's no way I should just take the charge.
We're going to get to your priors. Let's stick with the felony battery. Are you finished?
That's what we're talking about.
Are you finished?
My priors leads up to that felony battery.
Are you finished?
Come on.
Are you finished?
Come on.
If you're going to have a conversation with anyone, a part of it is listening, okay? I listen to you, listen to me.
I'm listening.
You can be charged with felony battery based on 2 things, Mr. Davis. Felony battery based on priors. The state has not charged you with felony battery based on priors. They charged you with felony battery based on great bodily harm or permanent disfigurement. And it doesn't matter if you 2 live together or not. Now, if you're saying that whatever harm the state is alleging doesn't rise to that level, that's a question for the jury. Okay?
Can I say something again?
Yes, sir.
Okay, so we're going to go back to what you just said now. We're going back to what you just said in the beginning. They're not charging me on my priors. I know that. Okay? But they're trying to sentence me on my priors. Okay.
We haven't got to that point yet. We haven't got to,
You literally just.
we're
brought up
talking
the
about
prize
felony
of-
battery.
to talk.
We haven't got to the
Okay.
score sheet.
So we're going to talk about this.
Yes.
Okay. So now we're going to talk about felony battery, right? You saying no matter the disfigurement or the bodily harm, you yourself.
I didn't say no matter the
Yes,
disfigurement.
you said no matter the disfigurement if I cause disfigurement and all of that.
Permanent
it's for the
disfigurement.
jury. But you yourself watched her walk in this courtroom, as well as other officers walk in this courtroom, get out stomping. You've even said
I
something
don't know
to her.
who you're talking about.
You've even said something to her. When I was standing up here.
I
you
can
said-
say something to whoever I want to.
You see,
But listen to me, Mr.
See, now
Davis.
you're just trying to, okay.
I don't know
Now you
who the
want me to
victim.
be quiet.
I don't
I'm
know
saying
who.
too much.
I don't know who the victim is. I don't know what the allegations are.
I'm telling you now.
Okay.
When she sat right there and I was standing up here, her and her sister went to snickering and everything, you said something to her. Y'all gonna have to get out of this courtroom, get out of here. We're not with all of that.
Okay.
And they got up and walked out.
Okay.
You telling me you didn't see none of that. You haven't seen and watched nothing. You don't even remember that. Not even remotely remember that at all. I'm talking to you man to man, not judge the inmate. I'm talking to you man to man. Like you telling me you haven't seen that.
Well, let me clear that up. This is judge to inmate.
Man, listen, we're men. I'm asking you a simple question. Did you or did you not see her sitting there when you said something to her, get up and stomp off?
Have you received a copy of your score sheet?
Yes.
And what
I like how you
priors?
stopped
What
that.
priors on your score sheet you say are not yours?
A bunch of them. As I've said to him on the first time he sent the score sheet and the second time he sent the score sheet.
Have you explained to Mr. Williams what priors on your score sheet you believe are not yours?
Yes.
Mr. Williams, you want
As
to
I
respond?
explained to Mr. Hill too.
Mr.
Yes,
Williams, you want to
sure.
respond to the score sheet issue?
Yes, Your Honor. We went through the score sheet and I went down the score sheet with regard to his priors, offense by offense. And I took notes to the ones, there were 2 or 3 to my recollection. I don't have those in front of me. He basically felt there 2 or 3 of them were not him. I said, and I marked those.
You're lying.
Mr. Davis, don't interrupt.
Oh, hey, listen. Just take him off my case. I don't want to talk about it more. Just take the man off my case. I'll do what I got to do, man. Just take him off my case.
Mr. Williams, continue.
Take him off my case, man. I don't want to talk about him. He's lying. You're going to continue to listen to this man lying, man. Don't
As I recall, there were approximately.
I'm gonna ask you one more time. Don't interrupt. We're in the courtroom. Just be respectful.
I don't want to talk about it no more.
Whether you want to talk about it or not,
I just want him off my case.
I have a legal obligation to go through this hearing with you.
Him off my case.
Mr. Davis, excuse me, Mr. Williams, continue.
Yes, Your Honor. As I recall, there were approximately 10 or so priors. There were enough that on the supplemental score sheet, it was full, as well as the space on the first page of the score sheet. And I went through each and every one of those with Mr. Davis and asked him, because he had made sort of a general averral that some of them were not him. He wasn't involved in them. They shouldn't be on a score sheet. I said, okay, let's go through them. I went through every one of them. As I recall, there were 2 or 3 that he said, that's not me. I didn't do that. I was never convicted of that. So I took those notes and I told him, okay, I can't give you an answer right now. I'll look into it. And before we go to trial, this will get resolved. You know, I didn't have the resources to look it up right then in the jail. So that's the long and the short of it.
Have you reached out to the state to confirm whether or not the priors on the score sheet are actually Mr. Davis?
I have not, Your Honor. I saw this was a meeting in the jail that I had with Mr. Davis. I believe it was last Thursday, and I haven't had the opportunity to reach out to the state as I'm out of town right now. I went out of town on Friday and haven't returned yet. But of course, that is my plan, to reach out to the state and even to, conduct independent sort of investigation with regard to it if I have to.
Okay. All right, Mr. Davis, anything else?
Take him off my case.
All right, Mr. Williams, anything else?
Nothing, Your Honor. Just the first thing that you were discussing with him with regard to the felony battery thing, that's just his position. I think he finally made it clear is that he believes, since he was in a domestic situation with the alleged victim, that therefore the maximum charge.
No, I want in no domestic situation. Don't say that, because I ain't say that.
Is a misdemeanor domestic battery. So I explained to him that when the state charges great bodily harm, You know, it doesn't matter what kind of relationship you have with the victim. It's a felony.
You said that? You said that to me?
Thank you, Mr. Williams.
Okay, I thought so.
All right, Mr. Davis, on the issue you raised, the felony battery, I've told you what the law is. Regardless, the state's not charging with felony battery based on priors, and
But y'all
regardless.
have your own law here?
I'm gonna ask you one last time.
Okay.
Don't interrupt me. You do it again, you're gonna be escorted out of the courtroom.
I'm gonna go anyway.
Mr. Deputy Tover, you can get him out of here.
Hey, but I'm push. Hey, don't push me for
All right, as to the felony battery, the state's charged him with felony battery based on great bodily harm, permanent disability, or permanent disfigurement, not based on priors. The priors on the score sheet, Mr. Williams, you indicate you two did have that conversation. You're going to conduct an independent investigation, also reach out to the state to confirm whether or not the priors on the score sheet are actually Mr. Davis's. As to the credibility issue, if it's her word versus his word, that does come down to the jury making that decision. On the racial terms, you tell me you did not make those comments, and your opinion of whether or not he needs to accept the plea offer is not ineffective. So based on what I heard today, I'm not going to discharge Mr. Williams. I'm not going to find that he is rendering ineffective assistance of counsel. And that'll conclude the Nelson hearing. Anything else on this case today?
That's nothing else from me, Your Honor, except I would request that just in case we do get a resolution before the October 28th, that we come back on that October 25th date as well.
Yes. And I'm also need to put on the record that Mr. Davis was disruptive of the proceedings, and he was removed from the courtroom prior to the conclusion of the Nelson hearing. We'll come back on October 25th for trial management, and we'll have jury selection October 28th.
And that October 25th, I believe you said, was at 9:30 Eastern time?
Yes, 9:30 Eastern time.
Thank you, Your Honor. You have a good day.
All right. I keep thinking that inmates act like that because, one, they're not scared of jail. Two, the justice system talks a lot about inmates' rights. They don't really spend a lot of time talking about victims' rights. I know in most states, I know in Florida, we've got a victim bill of rights, but that's rarely talked about and it's rarely challenged. Victims continue to be victims, and inmates continue to think they're getting smarter and smarter, and they continue to try to outplay the system. Sarah Boone in Florida, she got, I think she got 7 or 8 lawyers before they finally did her in and told her she had to represent herself. But the fact that you can get that many, I like Judge Stevens in Texas. You know, he'll assign a lawyer, and then when you say you don't want that lawyer, he doesn't give you another one. You know, you've got so many days to have your own lawyer, and so I like that one there. Again, just thanking everybody for being so active in the chats. I'm told it does something for the channels. I'm not sure what it does, but I appreciate it. We're going to jump to Judge Simpson. Yesterday, he had it looked like he was just having a rough day yesterday, and it just looked like everybody was unprepared, and he was taking it pretty hard. So here we go on that.
What I gotta say. They're right. I'll get it.
Good morning, Your Honor. Rebecca Chiappa, P62311, on behalf of Benelli Cruz.
Your name, ma'am? Thank you. All right, what are we doing?
Your Honor, we are requesting to schedule a preliminary exam at this time.
All discoveries complete?
Yes, I believe so.
Ms. Chiappa, have you come to my office and picked up all the videos? I spoke with Mr. Burgess, who indicated he needed to bring a large hard drive to get them all. Were you able to do that?
I have not. I will do that.
So discovery is not complete. I'm sorry. You know. Oh dear. Okay. Why do you say that? What's wrong?
She's not giving us everything. She's just not really doing what she should.
Okay, let's. Was this a MAC office appointment in this case?
I don't know. I know the PD had a conflict.
Yes.
So it was a PD case. Then you were appointed counsel in the case. Have you met with your attorney? You expressed your displeasure with it? What do you mean?
Like I met her and then I had to tell her. That's all.
Well, did you know it was going to be set for exam today? Okay.
If I may, Your Honor, Mr. Burgess, who represents the co-defendant, is going to request to adjourn the PCC as he has to obtain the remaining videos, which I.
Well, I don't know why, Ms. Jabo, you were setting her exam and don't have the videos. I don't get it. Question mark. That's a question.
I'm sorry, Your Honor. I'm confident that I can take a look at the videos. I have the other discovery and will be prepared for the preliminary exam.
Counsel, I get it, and I'm not questioning one's efforts or whatever. But she's charged with aiding and abetting a homicide.
Of course. I would suspect that setting a
Okay,
preliminary
so
exam
I'm
would
just gonna do
be
this
the
on
next
mine.
step.
I'm gonna grant your motion. Somebody get to the MAC office, tell them I need a new attorney to represent this defendant. Take her back. I'll bring her back out momentarily and we'll figure out what we're gonna do. Okay, Ms. Cruz? You're probably all the way down the hall, you think?
I think so.
Yeah. You're seeing you is my pleasure. Court calls the case, People versus Jabari Holmes. Dear God. I mean, woohoo.
Good morning, Your Honor. Christina Costantino, appearing with and on behalf of Mr. Holmes. Mr. Holmes, please state your name for the record.
Thank you.
Your Honor, this is the contempt step for ACC. I have just been appointed today on this matter, so I would be asking for an adjournment of the PCC so I can obtain all the necessary discovery.
All right, you want 2 or 3 weeks?
If we could do 3 weeks so I can ensure I have all the videos, that would be.
Gotcha. Probable cause, October 3rd, 2024, 9 a.m. Bond in this matter will continue. Thank you, sir.
Could I address bond?
Absolutely.
Thank you, Your Honor. It's my understanding my client's bond is currently set at $75,000 with no 10% provision. We are asking for the court to consider at least a 10% provision or a reduction in bond. He's 29 years old. He's currently employed full-time at Enterprise, where he is a general manager. His employment is in the nature of managing data portfolios, and he's worked in that capacity for the last 2 years. He does have 2 children that he provides support for and takes care of on a regular basis for young children. He does reside in the Ann Arbor area. It's my understanding that I don't believe he has any history in about the last 10 years or so. So we would ask for a reduction of bond. We can follow any and all no contact order, and a GPS tether could be imposed should the court have concerns about his whereabouts.
Response.
I'm very thankful that he doesn't have a history of the past 10 years because he was on parole for home invasion until 2021. So he's otherwise been law abiding while he was under NBC's jurisdiction.
his criminal history has counted at least 6 home invasion cases while I've been sitting here, but he does have prior home invasion. His bond is 75,000 cash surety, however, I'm requesting 250,000 cash surety, which is the initial bond request that my office made. He does also have goals. He has a bond denial in Trenton for a visa. So if we were to release him here, we would be him to wherever Trenton is in Michigan.
Really? How long have you lived in the state? Never mind. That was that whole Canadian thing coming back. Go ahead. I'm sorry, Miss Hughes.
Before the former how close Trenton is to Canada?
Please. Very close.
I think it's South Canada.
It is.
Go ahead.
So in this case, he broke into a home while the 3 family members were upstairs sleeping. While he was in their home, while they were sleeping, he stole numerous items from their home, including a laptop that tracking. Victims woke up, discovered that they had been robbed while they were victimized in their own home. And the laptop, the police then took over the investigation, were able to link the laptop directly to the defendant's whereabouts. Again, Your Honor, I'm now requesting 250 cash surety, which is the request we've made from the time we charged this case. Thank you.
Your Honor, I strongly believe $250,000 bond or any bond increase is not appropriate. I understand the nature of the facts. However, even if the facts as the people state them are true, which we strongly dispute and he maintains his innocence, but even if they are true, there wasn't anything assaulted mentioned in that series of alleged facts.
Because they didn't wake up. Never mind. You don't have to worry about that. They didn't allegedly. All
Allegedly,
right.
Your Honor. And
I won't raise the bond, but I'm not lowering the bond. Motion for bond reductions tonight.
Thank you, Judge.
Thank you. First case, People versus Leroy Fedorko.
Caroline Foster,
Your name? You're requesting an adjournment
Yes, Your Honor.
to review this.
I'd like to address that.
Okay.
Obviously, the defendant is out of custody. This is a domestic violence case where he poured bleach onto her. She was hit with a chair and her left arm and head. However, there's more investigation going on based on the fact that she went to the hospital that evening. We have Washington County now taking over the case and investigating it further. My concern is that
Who was investigating it initially?
it's Lenny. Please.
Okay.
So there are going to be higher charges being brought against this defendant, I believe, but he's contacting the victim, and I have text messages I sent to the PD's office as well as the case. So I'm asking for a vote bond today, based on the fact that we had asked for a higher bond in this case, and a $5,000 cash surety bond was ordered to begin with. So I'm concerned the minute he got out of custody, he started contacting the victim on text messages.
Any response, counsel?
No, I honestly don't have any evidence or discovery of those alleged violations.
You said there were text messages that were sent to the.
From the defender's office, I believe it was Mr. Gaddy was on it originally, and he said he was off the case. I didn't know who was on it.
Got it.
Our office we just jumped in yesterday. So we have not received any of these letters.
So let me just, here's what I'm hearing, that there may be higher charges coming because in part the use of bleach on the defendant.
No, well,
Or-
she was sent to the hospital and more allegations came out.
Got it.
So now there's gonna be, I'm pretty confident there's gonna be more charges added in this case.
Got it. And then the other thing is that since the time of his release, the people's allegation is that he's been violating the condition of his release by contacting the victim in this case. All right, you don't have that information, counsel, before you at this point. All right, what I'm going to do, defendant's remanded to the jail. We will bring him out. We will let you see that information so at least you can make a preliminary argument, and I'll pass the matter. Defendant's remanded. They need to hold him up because when she gets, they need to keep him up here so when she gets this kind of. Court does call the case, People versus Jonathan Lilly.
Ready, Your Honor. Andrew Childers appearing on behalf of the people.
I was confident in the name. Go ahead. You see, he's in custody? Where is he? Oh, he is. You got him? Okay. Yeah, I guess that was because he went back, so I thought we were doing that. All right. All right, what are we doing?
Your Honor, today is the date and time set for continued probable cause conference. We'd like to set this matter for an exam.
All discovery is complete?
Yes.
People have their witnesses available the 24th?
That should be fine.
Preliminary examination in person will be set September 24th, 2024, 9 a.m. That is before Judge Washington.
Is it in this building?
Pardon?
It's still in this building, correct?
Absolutely.
Your Honor, can you put our exam towards the end of the, and I get a right to do that with Judge Washington?
So when you came in, there was a menu, right? And so you're able to like order stuff off of that? I just assigned this to Judge Washington. If you want it near the end or however that happens, you need to get to Judge Washington.
Okay, Your Honor.
And when you ask her that, let me know what she says. Go ahead. What?
Your Honor, one other matter, which is the matter of bond at this time, my client has no bond set. And he's been in the jail for nearly a month. He was out on bond. He was complying with everything. There was the standing about testing.
Oh, yeah, so he wasn't complying, but go ahead.
So he misunderstood about the testing. After speaking with me, understood that he needed to continue testing. He did come in on his own to test, and he told the testing people that there was a link to his arrest. So he was very open and honest, Your Honor, and trying to be fully compliant. He has no criminal history. And Your Honor, in this matter, the victim herself had alcohol and multiple drugs in her system and was not wearing a seatbelt, and so on. So Your Honor, I would ask that you consider reinstating this previous bond.
Your Honor, in this case, the defendant was traveling in excess of 100 miles an hour downtown Cincinnati when he crashed with his car killed. So.
Your Honor, we dispute the speed.
Not from a crash, the construction, the vehicle data report.
Yeah, Your Honor, the police report says 86, but.
Oh, 86 as opposed to 100.
It is lower. Your Honor, he's been abiding by everything else. We'll be doing the test.
He missed 4 successive tests. The test before that had an abnormal creatinine level. Test before that was, you want me to go through it? Because we've been through all of this, Ms. Sussel. Motion for bond or your request for bond reduction is denied. Bond will continue, and you'll continue on to preliminary examination before Judge Washington.
Your Honor.
Court does call the case, People versus Alan Maloney.
People.
Afternoon, Your Honor. Thomas Stringer, here now. Mr. Maloney.
Good seeing you, sir.
Good seeing you. My name is Alan Maloney.
All right, we've got a couple things here. Have you seen the bond violation, counsel?
I have.
All right, why don't we address that first before I address any of your?
You want to hear from Mr. Maloney?
Either one of you, I guess.
Mr. Maloney is admitting that he had and he was having trouble with the train, but he still should not have consumed alcohol. We understand. I actually took it into Department of Corrections on Monday to set up the machine. So now we've agreed to do a scram. It would be better than small. And you agree?
Is that correct, sir?
The next request for people as well as the defendant, to the scram cutter. I know that Mr. Stringer is also looking for an adjournment, so that way the defendant can get into treatment at non-harm and see how we may be able to continue to talk about the case and resolve it. I'm optimistic about that as well. I think that this is somebody who needs help. And I'm hoping that being on the scram will give me the peace of mind that the public is safe will work on decisions.
Okay, Mr. Maloney is, I'm not talking specifically, but second in line would be non-harm. So let me talk to them. We're going to adjourn this to the 26th. Look like maybe one. Or would consider even a longer adjournment. I need to know, you know.
Right. Well,
We'll come in on the 26th.
well, let me just ask this, Mr. Maloney. If I put you on a scram, do you think that's gonna at least assist you in some way, or what?
Yes, I'm already abstaining from now. But I understand reasons for putting me on the screen. I've discussed it with him, and he understands the scram is probably in his best interest.
Okay. And you've already called Don Farm, you said?
Yes, I've been contacted Don, so he's filled out the intake. But I probably will call just to make sure.
What I will indicate is defendant admits to violations. Yeah, be okay. Defendant to be placed on a scram tether. And I'm signing that order right now. So you might want to get it before you leave this today, because they're right over there. Then I will adjourn. In all other respects, I'll have his bond continued. I'll adjourn the probable cause conference.
Consider as far as.
In one way, I would, to give him time to show me that he can operate with that. Do the people have a position on that?
I leave it in the court's discretion. I discussed with Mr. Stringer that because the defendant did have a bond violation today, the court may want to see him again in a couple of weeks.
Yeah.
Sort of keep an eye on things, but I was comfortable with going to October, or was knowing that he'll be on that scrum tether and we'll get notice of any violations quickly. Mr. Stringer also has represented to me that the defendant doesn't have a vehicle anymore, so he doesn't have the ability to drive.
All right. Well, here's what I'd like to do. I guess my thought process was gonna go to October 3rd. And then kind of move from there, but I don't know if you can or not, Mr. Stringer.
I can't do the 3rd.
Okay, that's fine.
I'm luckily in Florida.
Oh, well, then I'm setting it the 3rd. No.
I know, I saw you.
Yeah, exactly.
And part of the problem is
Well, the 26th will work. I just wanted to make sure that you're where you are, and then we can kick it out from there. So I'll go to September 26, 2024.
And would we be able to do in the afternoon?
Yes, your private counsel will usually be in the afternoon.
I'm in bankruptcy.
All right. We'll work with you on that. Okay, we'll do that, get on that, make sure that that's going for you, and then we'll go from there.
You want him to go over right?
Yes, I'd like him over there right now. They know, and they'll be able to put one on. You were on SoberLink, right? Do you have that device with you? Pardon?
No, I don't.
Okay, because they're gonna want that device back, so we'll figure that out, but I'd like him on the scram now.
I'm taking you home.
Okay,
So I will grab you.
okay, very good. Thank you, sir.
Thank you.
Great seeing you. Court calls the case of the people versus Yolanda Eckel. Yeah. Court calls case people versus Brett Thompson. All right, I had set this, I mean, I think the record is clear. Mr. Thompson had indicated he was going for a particular reason to North Carolina. I revoked that privilege to go to North Carolina. We had one hearing, then I set this hearing off of that, and he's not here. Is that correct?
Yes, sir.
Do we have any idea whether he's in custody?
I tried to look up in Iredell County to see if he was in custody, and it doesn't show that he's in custody. I also had further information that is, I know he had informed the court that he went to North Carolina as a family vacation because his mother passed away and he's gonna spread her ashes. And I have information that his mother passed away in 2021 from a car accident. So that's also concerning.
Yes.
Lied to the court. He has a matter pending in North Carolina, obviously that's extremely serious, that involves guns, ammo, and a lot of drugs. So he asked that you revoke his bond, or you bench warrant him.
Yes.
At this point, Judge.
Any response?
No, Your Honor, I will try to see if I can figure out whether he's in custody. I actually don't have any information about that at this time.
Bench warrant will issue for defendant's failure to appear. I will set no bond at this time as bond on another matter is revoked. That warrant will issue immediately. Thank you. Court does call the case, people versus Peter Heenan. Bless you.
Jessica Williams.
And may it please this honorable court, Michael Nichols on behalf of Mr. Heenan. Thanks. I have quite a few things going on.
Yes. Mr. Heenan, how are you, sir? State your name. All right. Okay, where are we now on this?
I picked him up at U of M about 2:15
Today?
today.
Okay.
I took him to his apartment so he could pack a bag. Had my eyes on him the whole time.
Yes, sir.
He is on 2 medications right now for seizure concerns because he's detoxing. Obviously, he's prepared to acknowledge that he's consumed alcohol. He had been on the phone with Bear River. Off the record on Tuesday, we talked about that.
Yes.
And if you recall, there's an order in your file from July 3rd where you ordered CMH to do an assessment.
Yes.
It was the issue of Mr. Heenan being private pay. And what happened was he never was assessed by Washington County CMH.
Oh.
He ended up going to Liberty House in Livingston County for just, I think, a couple, was it 14 days, Peter?
It was 24 days.
24 days.
Too short.
So same problem still exists with Bear River. We were on the phone with them from about the time I picked him up at the hospital to his apartment at Arbor Road. It would be about 10 to 14 days before they could get him into the bed, and he'd have to private pay. Sanford House, which is a facility in Grand Rapids where I've had clients go before, they do dual diagnosis. They would do a 90-day treatment. They'll accept his Blue Cross. They've got a bed available. We also checked with Liberty House again. They've also got a bed available. They also have dual diagnosis. We talked off the record about that as a concern. I would offer that we go into whichever one is closest and the most available. And if there's any delay for whatever reason, I don't think there will be. He's got the companion service that I mentioned off the record. This is the agency. I've never done this before, never heard of it, but apparently they bring a 24-hour support person into your home to make sure you stay sober, don't engage in maladaptive behavior, and get you to where you need to be until that bed is available.
it's the same thing, if not better than the jail alternative, which has the big benefit of sobriety, but that's the only benefit. Offering, he's still wearing the scram bracelet. And he at least, got himself to the ER on Monday morning, Monday morning, and started detoxing. So that's where I'm at this moment. And I did provide to the court, and I think to Ms. Blanche, I think they call it the hospital audited assessment. It's kind of
Yes.
living document from the first time up there to get the water on there.
So there are beds available for him now.
At two facilities, Sanford House and the House. And I listened myself to the phone calls.
Is there anything from the people on this at all?
I'm obviously just concerned based on obviously he was in custody, he was released on a scram. He had been testing positive for benzos and alcohol. Originally, he had missed tests and that's why he was in custody. And then he got released, and I think the drug testing fell off for some reason because then he was released on a scram. So now, he was withdrawn from Pretrial. He was also positive, obviously for benzos prior. So I'm just concerned, I would like the drug testing aspect to come back on if he is, that he needs to be an inpatient if he's going to be in the community. I don't know if he's driving or what's going on, but obviously if he cannot stay away, be clean, and he's on the roads or whatever, that's a huge concern. He's had a lot of, he's been violating and he's had a lot of chances, to be honest. So I don't know. And I get it, but his case has been going on since June, and I'm just, to move this case along, I realize he needs help, but at the same time, we have a pending case of a victim here, that, would like to see the case move forward.
Right. And I realized that you were not part of what we had on Tuesday. And so I would just say this. This gentleman has a lot that's sort of happening life-wise, including, and I'll just say this, I mean, some of the things that are happening are, and I'm going to put it in my simple way, but I'll say it's really a result of the grieving process of the breakup of a family. And for him, that's been a huge piece of it. My understanding is from my notes that I had, I think he said 16, 17 years sobriety. And then it just, he's not, if I thought he was playing a game, and you know how I am, then I don't have a problem putting him in. I don't think he's playing a game. I think he may be in some ways unwittingly playing sort of a Russian roulette with his life. But I don't think he can help it. I really don't. He was in, and I understand this, Blanche, when you talk about danger to the community, but I also realized this was a gentleman who was at such desperate points that at some point he could have gone out and drove when he was having these sort of this other relapse. He could have, he didn't. It's like he knew enough not to do that, but he had then the alcohol brought to him. And so it's sort of strange because the danger wasn't really to the public. I mean, it's almost like he was conscious enough of that. the part he wasn't conscious of was the danger that he was posing to himself. And I knew that when we were here, supposed to be here the last time, and Mr. Heenan wasn't here, and I was getting the report, that my great fear initially was we were going to find the worst. I'll be honest with you. That's what I thought. And council showed up, and I think council was worried. And when council said that I gave some time on the warrant rather than issue it right away, and council said he was going to go out and he was going to go himself. Extraordinary, in my view. Watched a lot of lawyers practice, do their craft, but that was extraordinary. By the time he got here on Tuesday or whatever day we were here, he knew where you were. He knew what they were saying about what they were going to do with you and things like that, and was trying to game plan what to do. Extraordinary. So I get all of that. I don't. We got to get him into. Just got to keep getting him to treatment. Trying. Shane, is there anything you want to say before I? Pardon?
Very sorry for letting you down. I agree.
Shane, and I appreciate you saying that. Not necessary. This job, I tell you, is a weird job. Because the happiest thing I was when I got off the bench and I was walking back and then gonna come back out. Greatest thing in the world was that I saw you. Because I didn't know. I mean, I knew counsel. I knew he was trying to do things. He's communicating with the office. But I didn't know. So there's not an apology needed. You have to just realize, sir, you're not alone. You're just not alone. And I know at times it seems that way, right? Especially in your circumstance where you don't have your family. And we had talked about that in our conversation. And I don't entirely get it, but I get part of it. But you just have to know that you're not alone in this whole thing. It's a rough journey, right? Okay. And appreciate that you're worth it. Okay? I don't think all of us would be here if you weren't worth it. As a human being and as a person, you're worth the effort. Okay? And always keep that in mind. Life can look so dark sometimes, but really, if you think about it, on balance, life is grand. Right?
I know it was 16 years.
Yeah. And now we just got to find a way to get you back there. Right? So let's walk it. Let's do it. Sometimes I do stuff and I say stuff and I'm not sure why. But sometimes my gut just tells me something. I want you in the place in Grand Rapids. The one out west. I understand council said someplace, but I don't know what's telling me that. But if that's where we can get you at, I'm just, that choice, I'm just gonna go with my gut on.
It's 100%.
How can we get you there? How are we gonna make that work? Now, they said that there was a bed. So how are we gonna get all that set up?
I would have to give them a call, communicate. Obviously, I'm not gonna drive.
Right.
My oldest lives in Grand Rapids.
Pardon?
My oldest lives in Grand Rapids. I can make an excuse to go with that. And you know what? You don't know me, Your Honor, and neither does Miss Blanche. My plan today was to be at Comerica Park watching Terry Google pitch. And I thought about it. I said, how many times do you get to see that? But how many times do you get to try to save a life?
That's it.
And that's what we're doing. Right?
Okay, so here's what I want. I'm not gonna lock you up. Right? I don't want to do it. I'm not gonna. You're to get enrolled, get yourself in a bed, and I want you there by tomorrow. Got it? And I trust counsel will report to both prosecutor's office and myself.
In the same fashion.
Yeah, just to give us a status of where he is and things, and when he's on his way there, and if he's in, he's in. Okay.
And then sober living after.
Absolutely.
Mr. Rosso said transitional.
Yeah, some type of, once that program's done, it's, and what we talked about. So basically you have to, the community that was supporting you before was ripped out from you. For good or for bad, I'm not here to say what the reasons are. It just was. And so you're wandering alone. Right? And so you have to sort of recreate a community for you and a community that will support you. One of the things that, I also said is, and I can bet you think you're the only one going through this, right? You think that you're and when you begin to think that, the world looks like a really lonely place, right? So we got to do this part. I mean, the idea would be to do this part. Then when you come out, transition, get into some type of transitional housing, be around people that are having the same struggle as you are, that can appreciate when you say something, they can appreciate it because they've probably been through it, and maybe stop it from occurring with you or stop that thought process from going. So that would be sort of the long-term plan of that. What do you think about that?
I completely agree. My biggest issue is I don't like to inconvenience people. And I need to get over that with sponsors and reaching out, fellowship. But I know I need it.
Do you think we're inconveniencing us right now? Do you think you are? No, you answer. Do you think you are? You're not. It's what we do, first of all. All right. And what and that's the big piece that you have to get over. You're worth it. If I have to do something for whatever I see worth in, then it's not an inconvenience. And if that's the case, you can't be an inconvenience, and you can't be inconveniencing us. You got it? So one thing that you learn about me, Mr. Heenan, and anybody will tell you this, if I give you my word, I'm going to walk that walk with you, do what I can. Some things I can't do, but if I say I'm going to do that, I'm going to do it. If nothing else, I'm a man of my word. So fair enough? So when you get in that mindset, particularly regarding this court, that somehow or another you're inconveniencing us or doing whatever, just almost have the trigger be for you in your head, you're worth it. Have my ugly face, as I've been told today it is, Thank you, Ms. Hughes. Uh, have my, remember my face telling you you're worth it. Got it? You're welcome. Thank you for being you. Thank you for showing up here. Thank you for being alive today. Because every day, Mr. Heenan, I wake up and I just hope that I get to see a miracle. Sometimes you don't even know a miracle when you see it. But what you've been on for the past couple weeks, the very fact that you walked through those doors, that's my miracle for today. Okay, so what I'm gonna do for a future date, I want him in by tomorrow. I'll just put it out 1 week, not expecting that we're gonna be able to do anything, but we'll at least have a date that's a check-in. Council, you can appear via Zoom if everything's all set. Anything else? So just set. Do I have a warrant out on him? Okay, I don't think so. So I'll set this for the 19th, 2024. I'll set it at 9, but see that I'll have his bond continue in this matter, and I will indicate defendant. It's Sanford House, right?
Sanford House.
Yeah.
Sanford Behavioral Health.
Yeah, okay. I'll get it done. All right, and we'll look for the updates. Okay, you're welcome.
All right. Judge Simpson there being Judge Simpson. One of the things that irritates me is whenever you look at the news, you see the cases of like the Yahoo that was driving with a suspended license that gets caught up, and you see other dumb stuff. Nobody wants to see us short on this. Nobody pays attention to this, and it doesn't ever make it. But I am surprised people made it this long. I think we are done for the night. It's 9:45. So, all right, we had a good night. Thank you, everybody. We'll see you tomorrow night, and make sure to give Lena's hell. She said she wasn't doing anything tonight, so make sure to send her a message on Discord. She wants to talk with everybody. All right, y'all have a good night, and we'll talk to you later.